Later, when we return from Parliament, we get to see and read your comments that you'll be sending on to our Facebook and Twitter and Instagram pages on TV3 Ghana. So let's head straight to Parliament now as the vetting of lawyer Kissi Agyebeng is underway.
So was it in dishonor to drop it?
No, Abuche. I made my peace with him that I needed to check that foreign name from my name and keep my local names.
All right. So, Chairman, just to, I'm happy you stated that you used to teach conflict of the laws and law of contract. Now, you know the evidential rule, burden of proof, particularly in criminal jurisprudence, proof beyond reasonable doubt. Do you share the view that we should criminalize unexplained wealth in Ghana? Do you share the view that we should criminalize unexplained wealth in Ghana?
It is a bit too, Honorable Chair, it is a bit too overbroad to state unexplained wealth. In criminal jurisprudence, criminal constructs should be more pointed, more focused, and clearly delineated because of the specter of someone ending up in jail, losing his liberty, or being fined heftily for an amount. And so if we are to place it in proper context, unexplained wealth, I would say that if the person cannot reasonably explain as matched against his lawful income, the amount of money in question, then that aspect, in my opinion, should be criminalized. But if you can reasonably explain how you came about that amount of money, then that should be allowable, that should be acceptable. So in your context, unexplained wealth would be reasonable explanation of the source of that property, wealth, or funds.
Chairman, just to take the nominee, I appreciate your response to it. If you take the United Kingdom today, where Ghana largely borrowed its legal system, largely, they now, for purposes of combating economic crime and fighting corruption, have what they call a reverse burden of proof, that the onus must shift, that when those assets cannot be explained for, an irrebuttable presumption is that they are acquired illegally, fraudulently, it may be taking advantage of the state and its resources. So they now go for a reverse burden of proof. Will you subscribe to that for Ghana in our quest, our collective quest to fight corruption? Thank you, Chair.
Honorable Chair, I'll link it to my answer to the first question. Also, pointing out that criminal constructs are very, very dangerous if not well thought out. A reverse onus clause, as the honorable member rightly put it, puts the burden on the accused person to explain to explain one way or the other the charge against him, rather than the prosecution bearing the burden of proving his guilt. In the context in which I answered the first question, of course, if the construct here is that you cannot reasonably explain as to how you came by that wealth or property matched against your lawful income, then it presupposes that I have already placed the onus on you to show as to how you came lawfully in possession of that wealth, property, or funds. So in that context, my answer will be yes.
So, Chairman, still there, you have like a public official, maybe at Public Procurement Authority, who has 9 million in his account. And for purposes of accountability, that's why every country that is committed to fighting corruption has asset declaration regimes, and the essence is that you should be able to match incomes, legitimate and lawful, with unexplained wealth. Now you have this 9 million in the account of a public official, and maybe 3-4 years back, that money was not there. It's probably because he's associated with political authority in power, and his income cannot explain a 9 million in his account. If you were a special prosecutor and that was brought to you, your attention by an ombudsman in the Republic, what would be your attitude to dealing with this matter? Thank you, Chair.
Honorable Chair, as I stated, it should be matched against your lawful income. And so I'll be looking at, in respect of the sources of that income. Perhaps the person in question earns some other income from some other vocation. Maybe he has a cocoa farm somewhere, in a forest area somewhere, and he earns money from it. That will be lawful. So whatever the source of the income is, should be lawful. So the aggregate...
So accepted, Chairman, accepted. So now, is it not a case that the state could say, okay, come and explain to us in the context of the British system how you got this 9 million? That's the reverse burden of proof. The proof beyond reasonable doubt is no longer going to be the onus on the state. But we cannot explain how come you have 9-10 million as public official in your account. And legitimately, there's nobody in Ghana from the president through ministers of state, except those undertaking businesses, who should have that quantum of money. You are to help us fight corruption. Wealth that cannot be explained. We want you to be the lead police in tracking and finding answers to them to save this republic. Can I have your commitment to that? Thank you, Chair.
Now, Chair, you have my firm commitment. You know, Honorable Chair, corruption is secretive and very, very complex. And most of the time, it transcends national boundaries. And unless the participants of the corrupt activity are opening up to you, it is very, very difficult to, on your own, establish that these funds came about unlawfully. And so, as I keep saying, if I were to place the burden on you, matched against your lawful income, and you cannot reasonably explain the shortfall as to how your lawful income falls short of your wealth, then I'll be asking you questions. Then I'll be calling you in.
Will you ask those questions as special prosecutor? How prepared are you to fall into the heavy shoes of Martin Alamichi Hamidu, given his enormous experience in the background? Many have referred to your age so far. Reading your CV, I'm encouraged that if you would be fair, firm, and courageous, we'll get somewhere. Now, it's indicated that the most veritable source of corruption globally, and particularly Ghana, is the abuse of conflict of interest. And many situations of unethical behavior is associated with persons' conflict of interest. What strategy do you have? People want to reward family and friends, want to reward other persons. Sometimes corporate entities that are formed overnight will win contracts and bid against very experienced hands in the name of conflict of interest and its abuse. What will you do as special prosecutor to give respect to the provisions of the Constitution on conflict of interest and barring public office holders from abusing that opportunity? Thank you, Chair.
Honorable Chair, there was a reference to heavy shoes of a named individual. Honorable Chair, I'd like to state that I prefer to wear my own shoes, in the sense that I am my own man and I'm coming with my own experience and I'm coming with my own experiences and professional training. In this quest, my conscience and my learning of the law are going to be my guide. My strategy is that I'm not naive to assume that I'm coming to stop corruption. There's no way I can stop corruption. God himself will not even acclaim to that. But I am going to make corruption very costly, very, very costly to engage in terms of conflict of interest.
Chairman, he has just said that he'll make corruption costly, high-risk activity. How do you intend to walk that road?
Exactly.
Thank you.
Honorable Chair. First, I'm going to institute what I call pressure for progress. And in this quest, there will be a systemic review of all public agencies.
What was the word you...
I said I have termed it pressure for progress.
Pressure for progress.
Yes.
Very well. I thought it was a Latin word you spoke. I didn't get it out.
I'm going to institute systemic reviews of public sector institutions and the development of integrity plans. And here, this is what I intend to do. Why can't we have our own corruption perceptions index, for instance? Why can't I rank public sector agencies against each other? And at the end of the year, publicize the results as to which institution is performing well and which institution is not performing well. In that quest, if you are head of an institution and persistently your institution is drawing the short straw in terms of the perception of corruption from the point of view of experts, from the point of view of business people, you will set up. Because
Special Prosecutor, you are aware that you are being appointed to operate a particular law. Where will you draw your authority to be publishing perception, corruption, or corruption perception index of agencies? Where under the law will you have that your authority from?
Now, the Act empowers me, if I'm given the nod by this House, to institutionalize risk assessment in respect of public agencies. And in doing risk assessment in terms of the activities of public sector agencies, it is a form of institutionalization of that systemic review of their activities. The Act also empowers me periodically, if I'm given the nod, to publish the activities of the OSP and the operations engaged in. In line with this, it is an offshoot of the mandates of the OSP that I could go ahead after the process of risk assessment, integrity of every public sector agency, to then come out with my results as to who is doing well and who is not doing well. It is an offshoot of that mandate.
Are you done with answering your question?
No, I'm not done.
Continue with that one and other members will come in.
From the Act, Honorable Chair, 4 divisions have been created therein. Finance and administration, prosecutions, investigations, asset recovery and management. I intend to create 2 more divisions to give more teeth to the OSP office if given the nod. The Act itself envisages that the OSP can create more divisions if it so desires. And I'll be adding 2 divisions. One, a strategy and research division.
Chairman, just hold it there. I'm not interjecting. Go to section 19 of your act and make appropriate references for our purposes. You are just special prosecutor. The law assumes that you have a board. And in answering the question as chairman posed it, the mandate is not just yours. So reference the board for our purposes, for our record. You only can create additional divisions with the concurrence of the board. Is that not legally accurate? Am I not accurate?
It is so, Honorable Chair. I believe, my apologies, but I believe I said the OSP. So when I said the OSP, it wasn't in reference to a person but the office. So the aggregate of the office, including the board. That is the context in which I placed it. Yes. May I proceed?
Very well. Yes. Honorable Gaga.
Mr. Kissi Agyebeng, congratulations. Honorable Chair, just to place on record that the Honorable nominee actually handed over to me as legal secretary. If you go through his CV, and so I'd like to congratulate him. But having said that,
Being a consideration of the OSP, would you consider yourself in a conflict situation?
not at all, Honorable Chairman. not at all. Yes, but it's important to make that disclosure. Yes. Yes, having said that, Mr. Agyebeng, when you were nominated as a special prosecutor by the Attorney General, I chanced upon an article written by a man who would be your predecessor if this committee gives you the nod. And in that article, you have been described in language that is not too palatable by the said former special prosecutor. Now, in it, he says that Mr. Kissi Agyebeng is a surrogate of a law firm. Then he goes on to further implicate you as one of the key architects of the botched Agyapa royalties transaction. Now, if you juxtapose these allegations with the role of special prosecutor as an entity that ought to be independent, you have your would-be predecessor, that is, if given the nod, describe you in such language. Honorable nominee, what is your take on this? Are you a surrogate of anybody?
Honorable Chair, then before I go on, there's one more disclosure that I have to make in respect of Honorable Member Bulsa North. I was actually the chairman at his wedding reception.
Chairman was right. That he almost said that, yes, I do on your lips too.
Honorable Chair, if I may answer. Whoever says I'm a surrogate of a law firm or implicates me in the Japa transaction clearly does not know me. Because if you know me, you wouldn't make such allegations. And so all these things that came up, I took it as coming from uninformed positions. Because I was not involved in the Japa transaction in any form or manner, by any stretch of the imagination, however fertile. As for relationships, as I just disclosed, the fact that I was so close to you at some point in our lives will not give you, or you not give me a free pass because of that relationship. And that is why I'm here. And if there is a matter, I'm not going to say because I know one person or the other, I'm going to give the person a free pass. I certainly will investigate. But the truth of the matter ought to be told. I wasn't involved in the deal. I was nowhere near it. Indeed, until it started coming up, I didn't even know what it was. For the record, that is the truth. And so I'm no one surrogate. As I said earlier, I'm my own man, and I prefer to wear my own shoes. If the law firm was named, it would have even been fair to me. But if you say I'm a surrogate of a law firm, clearly you don't know me. I run my own law firm. I've been running it since 2014 as a managing partner. I cannot be described as a surrogate of that law firm or any other law firm. Honorable Chair, that is my response.
You know, Mr. Agyebeng, you have also been described as a very young and inexperienced lawyer who is not fit for purpose. For, you know, these are descriptions that, Honorable nominee, what is your reaction to this? That you are too young and naive to be appointed to occupy a position such as the Office of Special Prosecutor. Are you, let me ask you this, are you experienced enough to occupy the position of Special Prosecutor?
Honorable Chair, first, the age. I turned 43 years on 2nd July, a few weeks ago. I qualified to be the President of this Republic. I am age mates with the President of the French Republic. Indeed, he should forgive me for saying this. I'm a year older than the Minister for Justice and Attorney General. We were mates at the University of Ghana and Ghana School of Law. He is the Minister for Justice and Attorney General. There's no question about his age. Why then throw issues about my age? In terms of experience, as I stated much earlier, I was called to the bar some 18 years ago. I qualified to sit on the Supreme Court of Ghana. Indeed, I'm 3 years past the qualification for Supreme Court. I have taught criminal law, especially in the University of Ghana, for 15 years, continuously. I see, if I'm not mistaken, some of my former students around this table. The Honorable Member for Ejuso is my former student. Honorable member for Medina is my former student. Honorable member for Kaikwe Central, I was their TA in conflict of laws. These are the products of my experience. They are here, right here, for everyone to see. And, Honorable Chair, to anchor on that, I have had a front row, although I have not been a prosecutor, properly so-called. I have had a front row to landmark prosecutions in this country. As defense counsel, I have been engaged in some very landmark cases, including the Tagore case, the Baglaskanko case. I conducted them. Honorable Chair, when Tiger IPI and Aremia announced come up with their investigative pieces, I am the one who supervises, and I've been doing this for quite a while, supervises the collation of evidence in order for presentation to the Attorney General. Without me, the Attorney General's office will be poorer in terms of those prosecutions. So I can go on, but my experience is out there. And going beyond this committee to the bigger house, thank the honorable member for Old Tafu, was also my former student. My experience is out there. It's on record.
Honorable nominee, the Office of Special Prosecutor derives its mandate directly from Article 88 of the Constitution, and that article is the one that vests the prosecutorial powers of the state in an Attorney General. Now, do you envisage a situation whereby the functions of the special prosecutor would conflict with the functions of the Attorney General, given the fact that these are functions largely derived from the constitutional powers bestowed on the Attorney General?
Initially, I would like to believe, Honorable Chair, that when this process started, you could tell that there was a clear and happy friction as to how it was going to go. And so some of us even pointed out to the then Attorney General, informally then, actually, that, I mean, as a lecturer of criminal law, when you see some of these things, you would have to tell those in authority as to how things should properly go. There was a concern of this friction between the Attorney General and the OSP under Act 959 because of the way Article 88 has been couched. Because it gives all prosecutorial powers to the Attorney General, but then, by way of delegation, the Attorney General can delegate a person or institution to carry on prosecutions. So what the draftsman did in Act 959 is a sort of taking that discretion under Article 88 from the Attorney General, putting it in Act 959 and saying that the OSP can prosecute on the authority of the Attorney General. It is stated in the Act. And so by that formulation, from the onset in the Act, the OSP already has the authority of the Attorney General because Parliament has said so. But that would not end the story if more delineation is not done. So it appears tenuously, but the draftsman also tried to do something in Act 959 by specifying the offenses the OSP can investigate, can initiate, and conduct prosecutions in respect of. That is corruption and corruption-related offenses. There is a problematic one, the last one, which says existent offenses in relation to corruption and corruption-related offenses. It's problematic because if it is not well thought through, then a lot of friction could arise there. The reason is simple. There are two main forms of offenses that may arise in this regard. One, we have what we call predicate offenses. With predicate offenses, these are offenses which forms component parts of a bigger offense. And so if the OSP is prosecuting an offense, but its component is not clearly delineated in the Act, in Act 959, and it is in the province of the Attorney General, some friction may arise there. And then the other form of offenses I would refer to as antecedent offenses. Let me give an example of the first one, the predicate offenses. For instance, corruption as an offense could have a predicate offense like money laundering. But money laundering is not specifically stated in Act 959. So the OSP can then go to the umbrella and say, okay, these are existent offenses that arise or are consequent upon corruption. There, the Attorney General could also say, look, money laundering is my province and not yours. That is what I mean. Then in respect of the antecedent offenses, these are offenses that are committed before a major offense itself is committed. For instance, if we take the offense of dishonest receiving under Act 29, something must have occurred before someone receives or disposes of property. That is to say, if you are dishonestly receiving, you are dishonestly receiving property that is the proceeds of a crime. It means a crime must have already been committed in respect of that property or funds for which you dishonestly received. If the antecedent offense has not been committed, you do not come in charging someone with dishonestly receiving. And in respect of the antecedent offenses, problems of friction could also arise in respect of the Attorney General. But I see the draftsman also tried to do something under Act 959. He said, the OSP, within 30 days after the end of a proceedings, should inform the Attorney General as to the case, its outcome, and all. But I think this can be solved by properly defining, in my opinion, the jurisdiction of the OSP. And here I would advocate that we should start thinking about, if I'm not being overbearing, the passage of a Corrupt Practices Act, which will capture all these things, spell them out properly, define them properly, and the rules will become clearer. Because I'm foreseeing that in the future, serious friction may arise in respect of these umbrella offenses if the thought process is not clearly deliberated on. That's my response, Honorable Chair.
Yes, John Puma. Now, the students
thank you very much.
Their lecture questions.
Yes, thank you very much, Mr. Chairman, and let me take the privileged opportunity to congratulate my lecturer. Mr. Kissi Agyebeng was one of the favorite lecturers on campus for us as law students. and I want to congratulate you for the nomination. Those of us who know you believe in your competence and what you can deliver for this country. So just rest assured that you have our backing. I have a few questions to ask you, though. Well, this one is now fulfilling my duty as a member of parliament. So as a defense lawyer, I mean, you have taught us criminal law. We know your inclination to defense. And you have practiced as a defense lawyer for quite a long time. And I'm happy you refer to some of the famous cases that you've been part. How well are you positioning yourself to now transition to be a prosecutor? Since if you look at your track record, your first inclination is to now look at the defenses possible in the act. Now you're supposed to be the prosecutor. How well are you now going to transition yourself to go after the actions rather than defending it?
Honorable Chair, let me take a little swipe at the honorable member. If you remember in tutorials, I always said, be neutral, be in the middle as an arbiter. And that is how I've conducted myself all this while. Of course, when I take my defense cap and I wear it, I'm coming all out to defend my client. But then, I have switched sides so many times, as I alluded to the fact that, for instance, in the announced cases, I'm not on the defense side ever. I'm always on the prosecutorial side because I have to give the primary information to the Attorney General's office to run with it. It's like a button. So I have had experience with that already. And because of the way I've always conducted myself in these things, it will be second nature to me in that regard. It is not new. It won't be new. And I'm ably placed to do that.
Great. Mr. Chairman, if you look at the Act 959, the act from which your powers have been defined, and if you check from section 28, where it talks about the powers of your office, up to section 46, it appears the same, almost the same provisions are provided in the Act 804, which is for the Economic Organized Crime Office Act, Act 804. You are given the powers of seizure, the powers of search, the powers to freeze accounts on suspicion of corruption, among even powers of confiscation to aid your investigations. And you even have 7 days where you can seize property or power before you go to court for confirmation of your orders. All these are also provisions in the Act 804. One of the nightmare of any lawyer, a practicing lawyer in Ghana, is where you are in court with, say, Yoko, and then BNI, which is now NIB, will be waiting to pick your client on the same matter. And it appears this is exactly what we are repeating also with your role. So a lawyer's client can be invited by Yoko on accounts of corruption or tainted funds or accusations of money laundering. And even similar provisions is also found in the Financial Intelligence Act. So FIC could also invite your client. On the same provisions, the Office of Special Prosecutor is also mandated by this act to call your client. What will be your advice as a special prosecutor in instances where your powers as defined in the act conflict with the same provisions in other acts as I've referred to?
Honorable Chair, the advice has come by way of statutory provisions in the act itself. Because Act 959, in Act 959, Parliament says there in the act that we should cooperate. Otherwise, it will be totally duplicitous and unfair to suspects. I think the reason why the other agencies act the way they do is because they don't have the final push of prosecutorial powers, because they would have to refer their dockets to the Attorney General's department. But in this case, everything terminates with the OSP. And so, in that sense, it is a bit different and unique from the other agencies like the FIC, YOCO, NIB, and ANSHRAJ, for instance. Yes. Since the Act itself is telling all these agencies to cooperate, that is how we need to go. Otherwise, one agency is doing something, another is also doing it. If we don't cooperate, for instance, suspects can easily walk through any crevices we will provide. They will gladly walk through because we are not cooperating, we are not comparing notes. If we cooperate and compare notes, then one agency can see its way clear to say, this falls directly within my province, and I should take it up. And the other agencies would have to let go.
Mr. Chairman, there is a raging legal debate in jurisprudence on law of evidence, on admissibility. Two schools of thought. One school says that evidence is evidence. It doesn't matter how you procured it, even if you stole it. It must be admissible. And in fact, in Ghana, some people refer to it as the Anas principle, where it does not matter even if you were deliberately set up to commit a crime. It is okay. That's one school of thought. Another school of thought questions the legality and the process of procuring such evidence, and describe it sometimes as a blackmail or unconstitutional on the rights of the accused persons. These scenarios exist in different countries. In America, for instance, they don't accept the first scenario in cases of Mapp versus Ohio. In India, several lines of cases reject illegally acquired evidence. But when you come to our jurisdiction, and most of the Commonwealth common law jurisdictions, our laws are not clearly defined on whether illegally acquired evidence must be admissible in our courts. As our special prosecutor, and especially with your background in your private practice, with more associated with the Anas principle, in a democratic environment as we have in Ghana, now that you are going to be the Office of Special Prosecutor, how are you going to marry these two schools of thought to ensure that constitutional rights of even accused persons are respected and fairness prevail even in such circumstances?
Honorable Chair, foremost, the Anas principle is not akin to illegally acquiring evidence. It's a different matter. But since time immemorial, Honorable Chair, I agree with the Honorable Member, this debate has been raging. But in recent times, I do believe that our Supreme Court has sought to bring some harmony in respect of these two competing theories that are fighting for mastery. And it has placed it in a more clear contest in terms of what will be acceptable and not what will not be acceptable. So the general rule will then be that, from my reading of all these decisions, the general rule will then be that, and that is how I'm going to go anyway, that if I'm giving the nod, that ordinarily, that's the general, ordinarily, evidence illegally procured will not go in. But then there are accepting circumstances. It depends on the exigency of the matter and the seriousness of the occasion. For instance, if we were to see someone committing blue murder right in front of our eyes, and we videoed him, like what happened with the infamous George Floyd case, are we going to say when the video was being taken of those officers because it wasn't with their consent, the court should not accept their evidence because their privacy was being breached. In that situation, a life was being taken. And it trumps the person's right to privacy, the person who is committing the crime. It trumps his right to privacy. So all said and done, we situate it in the context of a balance. How do you weigh it? That is how we're going to go. How do you weigh it? And if the evidence trumps the rights of the perpetrator, it should be accepted.
Well, Mr. Chairman, just a follow-up question.
No, you're done. Yes, I got.
Thank you very much. Mr. Kissi, on your nomination, let me congratulate you. In your earlier responses, you touched on the relationship between the Attorney General's office and the Office of the Special Prosecutor. I see in the enactment of Act 959 that we try to provide some sort of veiled amendment of Article 88 of the Constitution, using specifically 88.4, that says that all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. So I assume that the amendment or the passage of this act is hiding under the phrase in accordance with any law. But can you, given your experience as a criminal law lecturer, and I believe being a law lecturer, you do remember your constitutional law also. Can you tell me what you think about Article 88.3 itself? 88.3 itself, which says that the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. Is that the clause that we ought to have been amending?
Honorable Chair, as I stated earlier, it is clearly problematic constitutionally. And as I said, some of us expressed our views informally to the then Attorney General as to the constitutionality of the creation of the OSP. And Article 88.3, as you have identified, is the mother of this problem. And what Parliament has done is it tries to then marry with this provisions in Act 959, it tries to marry in a sort of sidewind fashion 88.3 and 88.4 by just giving the authority of the Attorney General, whether he likes it or not, in that sense, if I may be obtuse, to the OSP. So to prevent the situation where the OSP would then be always going to the Attorney General to seek his or her authority to initiate and conduct proceedings. And that is why I said that it appears then when the draftsman saw the mischief, that he hadn't really solved the mischief. He then at the back said, okay, when you finish, tell the Attorney General what you have done. There's still more work to be done. There's still more work to be done on this.
Work to be done by who? Parliament or you?
Honorable Chair, it has to be Parliament with my input and help when I'm giving the nod that we need to clean house properly to make things clearer. As I kept saying earlier, that friction may arise one day. Friction may arise one day if, for instance, a sitting Attorney General and a sitting OSP do not see eye to eye really on a certain matter. Serious problems may arise. Honorable Chair, I agree with you. It should have been, if they may forgive me, better thought through. But with what we have, it is food that is still edible. Maybe we can garnish it later, but we can still eat what we have now.
Chairman, which food? This one with salt or without salt?
Now, which have been a Kwauman, it can only be fufu and cracker.
Chairman, if the Honorable Ayaga will accommodate me, so lecturer, conflict of laws. What conflict have you seen between a constitutional provision and an act of parliament? Where should the hierarchy of respect be, in your view? And what should we do the way forward? I like your thinking on this matter, but go further. What should we be doing in order to realign the provisions of the Office of the Special Prosecutor Act consistent with Article 88 of the 1992 Constitution? Thank you, Chair.
Honorable Chair, of course, every law student knows that the Constitution takes precedence. But what should we do? I think I've intimated to it. The mother problem is 88.3. That is where the issues appears to be. And so if we are able to amend 88 in such a way as to lessen its mandatory language in that context, to allow other agencies to perform such a function, because in practice, I would like to believe from my experience that Attorney General's office is already inundated. And so these satellite agencies will need to augment.
Chairman, just a little clarity. So are you for a constitutional amendment to Article 88, or, to quote your words, cleaning up the OSP Act? Where do you stand? Are you advocating for review and amendment of Article 88 or specific to the Act? Thank you, Chair.
Honorable Chair, I'm not just limiting my insights to the OSP. I was also transferring it to other agencies, like the FIC, the IOCO, and all that. So all these acts, together with Article 88, must be thought out again and clean house.
Yeah, okay. So related to that and the federal house cleaning exercise that we may need to do, from your reading of the Constitution and then Act 959, do you foresee a situation where one will say that the mandate that is given to the special prosecutor is actually not exclusive, and that any time the Attorney General's office can take on any case that has to do with corruption, and also, parallel to whatever the Office of Special Prosecutor is doing, also prosecute those cases, and that we haven't really given an exclusive mandate to the special prosecutor?
Honorable Chair, the attempt was made, but the job wasn't finished. And it's because, once again, you had the problem of Article 88.3. It was difficult to go around Article 88.3 to exclude the Attorney General from it. And I would say Attorney General shouldn't be excluded from any criminal proceeding in that sense. Because of the way Article 88 has been couched, it was impossible then in 959, when the mandate of the OSP was being spelled out, to then say that the OSP has exclusive jurisdiction in respect of corruption and corruption-related offenses, and no one can come close. It was just impossible to do that because of Article 88. But with experience, Attorney General should always have an interest in terms of what is going on in respect of the conduct of criminal proceedings, investigation of criminal proceedings, initiation of criminal proceedings. Because at the end of the day, he is justice. Attorney General is justice. Everything any other agency does. In truth, the OSP is specialized, and it has a more focused approach to things. But whatever any agency does, it is to justice. And being Minister for Justice and Attorney General, that office should not be expressly excluded from criminal proceedings, conduct of criminal proceedings in that regard. So I won't go that far, but I will say we need to, once again, repeating myself, clean these things up in the general scheme of offense to make things more clearer.
I think this is my last question. Yeah. So my last question relates to a function of the OSP that I don't think conflicts with the constitutional provisions relating to the Attorney General, and that has to do with fighting corruption. I think the issues with the Attorney General has to do with initiation of criminal proceedings. But before initiation of criminal proceedings, every other function, we can legislate that anybody can do that. So in the area of fighting corruption, what do you think you can do? You've just mentioned corruption perception index ranking of public agencies. I think that under Section 2C, you are to take steps to prevent corruption. Naming and shaming can't prevent people from engaging in the conduct. So I think that you are well grounded in Section 2C if you do corruption perception index ranking of public utilities, public agencies and institutions. Beyond that, what new ideas do you have in terms of your functions and 2C, the objects of the office, to take steps to prevent corruption?
Honorable Chair, I think it should be obvious to everyone that we cannot fight corruption solely through the criminal law. It is also because we live in a society of ritualistic gift-giving. If you happen to have the unfortunate situation, just by way of illustration, unfortunate situation of having your back wheel land in a gutter, and someone comes to help you out, the person is expectant that you will give him something. This society is, this is what we thrive on. It is a ritualistic gift-giving society.
I'm saying that it's not just your vehicle landing in the gutter, but in the case of MPs, even if he greets you, he expects a gift.
See where the problem lies. And because of that, it is very difficult to distinguish the acceptable from the unacceptable. And this is what is informing my drive if given the nod. That if I were to just focus on the criminal law aspects, that is to say, prosecution, I won't go far.
Quickly, do you have any agenda in relation to election campaign financing? I'm trying to focus the question. Trying to focus the question.
Thank you. You're done. Now, Obiamo first. Yes.
Thank you, Mr. Chairman. Congratulations, Honorable Kissi Agyebeng. You are famously known to be a very good criminal law lecturer. and also a practitioner as far as criminal law is concerned. Now, we seem to have spent some time on the mandate of the office. Going back to the Act 959, specifically Section 4, where the mandate of the office is spelled out. And as you seem to allude, if the ordinary man wants you to explain to him what you are required to do as a special prosecutor, how would you put it? Especially where the impression has been created that your office is more or less not required or necessary, given that you fall under Article 88. I'm asking this specifically because of Section 4, because the impression is created that you fall under only 4.2. Well, if you look at even 4.3, it will expand your mandate. And probably we may not say that this office is not too necessary because of Article 88. Yes.
Honorable Chair, interestingly, when my name came up, my own kids were asking me, so Daddy, what is it that you're going to do if you're giving the nod? In simple terms, the office is to investigate, prevent, prosecute for corruption, and manage seized, frozen, or confiscated property. But, Honorable Chair, in terms of the relevance of this office, the day we scrap this office is the day we say goodbye to our fight against corruption. Its relevance is borne out by its attributes and its uniqueness. It is unique as compared to all the other law enforcement agencies in respect of its mandate, because no other institution has been carefully thought out and designed to fight corruption specifically as Act 959 has done. And, Honorable Chair, in respect of this, the Office of the Special Prosecutor is the gold standard under the UN Convention Against Corruption and the African Union Convention on the Preventing and Combating of Corruption. The international community, including Ghana, we ratified these conventions way back in the early 2000s, I think 2002, if I'm not wrong, that every jurisdiction requires such a specialized agency, which should be made independent, with a specialized trained staff to focus on the fight against corruption. Now, the, if I may say, flaw with Article 88 in terms of the Attorney General is that we sometimes require too much of individuals occupying the office of the Attorney General. Come to think of it, the Attorney General is a member of cabinet. He is part of the government. How independent would he be in terms of certain individuals if they were to fall foul of the law, if, for instance, they are also members of cabinet or members of the government? But in respect of the OSP, an agency, a person manning it, who is not part of the government machinery, who is independent, and Honorable Chair, giving the nod, I'm going to guard my independence jealously, who is resourced to undertake.
Honorable, in your family tree, how wide is your family tree?
It's an ending, actually.
Very well. So if you start from guarding your independence against them, your family, then you can guard it against everybody else. That's my charge to you.
Thanks for the footnotes.
Chairman, if I can
acknowledge
just
it.
honor Obi if you accommodated me. So, Kissi, Agyebeng, just to get your own words, how independent will you be from the Attorney General, from the President of the Republic, and from friends and family members? Thank you.
Now, Chair, so far as I situate myself squarely in Act 959 and its four corners and province, my independence is assured. If I go beyond it, then I'll be on my own predilections. But the Act itself expresses it in so many words, and that should be enough.
Yes, Honorable, we are done.
Thank you. I would like us to look at Section 71 of the Act, plea bargaining. How do you think this aspect of the law or the Act can be implemented without the impression given out there, especially given your position, that this area can be compromised?
Now, Chair, fortunately, there is an arcane provision in the Courts Act where the Attorney General is also given the power to plea bargain by some sorts. A person pleads guilty, he coughs up the money, disgorges himself of the unjust arrangement, and the state is happy to keep the money, enter a sentence of conviction against him, but he doesn't serve a prison sentence. It is not unique. We already have that practice instituted. And clearly, this is meant to put some money in the state covers. What's good does it serve? For instance, if you just imprison someone who has hoarded millions for 10, 15 years, he comes back only to go for the money somewhere he stashed it. Better it is to recover that amount from him to make that activity costly. So, Honorable Chair, we already have a precedent in the Courts Act for this.
Yes, the last one is about...
This will be your fourth one.
No, third.
Third.
The last one is about the whole role of the board of OSP. Indeed, I have heard some board members making comments about investigations of OSP. Would you say that, given the role of the board, they should be allowed to make comments on investigations which are being made by the office? And what are the implications of that?
Honorable Chair, the board is not supposed to interfere with investigations and the conduct of criminal proceedings. The SP, the Special Prosecutor, of course, answers to the board. But the Act itself clearly insulates the board from the investigation, conduct of criminal proceedings, and places it squarely in the province of the Special Prosecutor himself. So in that regard, the board should refrain from making comments and passing, let me say, judgment on ongoing investigations, because there is a high risk of a compromise. Leakage of information may arise, evidence tampering may arise, and it is in that wisdom that Parliament insulated the board specifically from initiation, investigation, and conduct of criminal proceedings.
Yes. No, let me give to Zero first.
Thank you, Mr. Chairman. And good afternoon, Honorable Nominee. I'm too tall for. Okay. Good afternoon, Mr. Chairman. Thank you very much for the opportunity, and good afternoon, Mr. Nominee. Mr. Nominee, before I go to my question, please, where is Damfa in Ghana?
At Imensa, you take the right down through Kweman to Damfa.
So that's still in Greater Accra region or Eastern region?
That will be in Greater Accra.
Greater, all right. Thank you very much. Now, my first question to you, Mr. Nominee. In September 2013, at a symposium organized by the Dankwa Institute, you presented a paper. And the paper was titled, "The Decision That Wasn't the Decision, a critique of the Supreme Court decision in the election petition case," unquote. In this paper, you argued that the decision by the Supreme Court was somehow erroneous. You said, you argued in the paper that the decision was somehow erroneous. And that, how do you juxtapose that position against the 2021 election petition hearing of the Supreme Court, where the EC chairperson was not made to testify under oath, which was actually central to the position of the NDC in filing that case? What are your thoughts on the Chief Justice's actions in reference to Honorable Dr. Dominic Ayini's comments, which were very close to...
Kindly take it one after the other. You answer one. You're putting two separate issues in one question. Break them up, please.
All right. His comments after the decision, which the Chief Justice took exception to and was cited before the General Legal Counsel. What is your position in view that your comments, very similar to his, were never cited before the disciplinary committee? Thank you.
Yes.
Honorable Chair, Honorable Ayine is my senior in chambers. Actually, he taught me commercial law, the Faculty of Law then. But I would say here that, before I answer the question, the comments are dissimilar. They are dissimilar in the sense that in 2013, when I wrote the paper at that symposium, it was an academic paper that's presented. And my conclusion was that I couldn't find a ratio in respect of the so-called majority judgment in the first election petition case. And my reason was simple. Some issues had been placed before the court. Two main issues, in my opinion, as to whether, number one, the second respondent then was validly elected as president, and number two, as to whether the first petitioner then was validly elected as president. At the end of the day, when I read all the decisions of the 9 justices, I couldn't dovetail it with the outcome that was stated by the president of the court on that day in August of 2013. And this is it. It appeared to me, and as I said, this was an academic paper, it appeared to me that instead of answering the questions that had been placed before the court that day, the court missed those questions and was answering different questions. So whether or not the second respondent was validly elected, that wasn't answered. But what was being answered was, for instance, whether there was overvoting, whether there was voting without biometric verification. So instead of the president of the court stating on issue 1, whether the second respondent was validly elected, President of the Court was rather stating how many judges voted on overvoting, 6-3. How many judges voted voting without biometric verification, 5-4, and the like. And to me, as a law lecturer, I didn't know what to teach my students at the outcome, because I'm seeing 5 justices saying that someone was not validly elected, 4 justices saying at the end that someone was validly elected, but being held to say that the 4 justices were in the majority. Because I couldn't find a ratio in that case, that is why I made that academic exposition. And in respect of the 2021 decision, in terms of the comments by my former senior, I actually had cause during the pendency of the first election petition to deliver another talk before this talk you referred to. It was organized by the CDD and the National Media Commission. And there it was in respect of free speech and accountability and the rule of law. If we will recall, several individuals, private persons, had been hauled by the Supreme Court and cited for contempt. And my consternation was that it appeared as if immediately your name was cited and you were hauled in before the court, then you needed to start apologizing. And so those who apologized immediately were let off. Those who decided to bring in lawyers to defend them ended up in jail. And that was what I was pointing out in the first paper before this paper you referred to. Indeed, at that time, the bar took umbrage at what I said, but I thought that I captured the conscience of the nation better by saying that, look, this whole issue of contempt as a criminal offense is so dangerous that if we are not minded to codify it, to define it well, and to come up with commensurate punishment, we will get to a situation where it will not be on national TV that day, but a high court judge sitting somewhere in Goso, there's no camera on you, cite you for contempt, jail you for 15 years. All you have to do will be to appeal. So I was sounding that caution, and that where we were going was very slippery road, and so we needed to rein ourselves in.
Before you come to this, let's go a little back into how did the concept of contempt of court develop? Was it by statute? It was never by statute.
No, it was.
The courts generated that to protect themselves from executive abuses. Parliament generated its own contempt to protect itself from executive abuses, because they again have powers, they have the agencies of force. The courts don't have. The Parliament doesn't have. So these two arms of government developed their own jurisprudence of contempt to protect the two institutions. So now, are you suggesting that Parliament should now make rules regulating how the court should now exercise their power of contempt?
Honorable Chair, absolutely. That is what I'm suggesting. It is dangerous, no matter how you look at it, if we are just to leave it the way it is. It is a common law offense, which has been accepted under the Constitution. But the danger, as I pointed out, is that because it does not have defined punishments for it, the punishment at some point may not fit the crime at all. And that is the danger. Because if you were to be cited for contempt today and say the judge gives you 2 weeks in jail, maybe you were let off. Same act placed before another judge may fetch someone 2 years. How do you justify that? It is a simple matter, in my opinion, of just delineating it. Okay, this act amounts to contempt. And in respect of this, if Parliament or the courts were to cite you for contempt and hold you liable, within these 4 corners, we can hold you liable. Honorable Chair, I think it is a safer course to go than to leave it open as it is. There's a clear and present danger.
Well, that's why we continue to have different opinions. But I didn't finish answering her question on Honorable Ayine.
I believe I finished.
You're done. Very well.
Thank you very much, Honorable Chair. Honorable nominee, my second question has to do with a report by the Center for Social Justice, which suggests that Ghana has lost up to 1.89 billion cedis in judgment debts. There's a school of thought that intimates that these judgment debts sometimes are not particularly due to bad contracts being cancelled, but due to schemes that have been cooked up by senior public office holders, sometimes in collusion with international organizations, with local companies, just to fleece the state. What will you do? How do you think your office, the Office of the Special Prosecutor, can work towards eliminating this canker so that Ghana can save a lot of money? Thank you.
Honorable Chair, I believe I answered this question earlier when I intimated that our institutionalized risk assessment, conducting regular risk assessment in terms of the avoidance of toxic deals. That is what you referred to. These are toxic deals, and also the avoidance of judgment and tribunal award debts. And then I also intimated that I would do a systemic review of public sector institutions and the development of integrity plans. And that is where I waded into my corruption perception index idea of anti-corruption barometer of state agencies. That will have teeth and it will bite.
Thank you very much. My final question. A lot has been said about your age, and you've alluded to your experiences up to this point, which you think will be a good guide for you in undertaking your job in this office. How will you, however, navigate our cultural settings where we revere our elders in society, we revere the big man, we revere our chiefs? In terms of prosecuting your work, somebody is under investigation, goes to see Nana or Bahima, she calls you. How will you manage this within the context of our Ghanaian settings? Thank you.
Practically, simply, I'll have less friends. And that is what I alluded to my earlier statement, that in the society of ritualistic gift-giving, gifts of goodwill, it becomes very difficult. And so just a reliance solely on the criminal law is not going to make it. Some practical, innovative things must come on board. If I start by having less friends, if I start by not picking calls, you will not approach me easily. But I admit, honorable member is fascinated by it. I will admit that, of course, if my village chief calls me and asks for a favor, it will be difficult. But, sorry? Yeah. It will be very difficult not to attend the call. But I said earlier in answer to an earlier question that if I place myself within the four corners of Act 959, I should be much more insulated from these things. But if I go out of it, then I open myself up for Jantua.
Very well. Honorable Minister first. Deputy Minister for Education, is that right? Yes. In that order.
Thank you very much, Honorable Chair. Congratulations, Mr. Kissi Agyebeng. It's amazing how you would drop one of my favorite names, William, which also happens to be the name of my father. Maybe you may consider transferring it to one of your prospective kids in the future. But I must congratulate you again, and going through your CV, the sterling legal credentials that you have, and listening to you, particularly on the innovative methods that you intend to deploy in the fight against corruption, I'm confident that you would succeed in the discharge of your mandate. However, there are just two concerns that I want us quickly to address. The first is your predecessor, when his nomination came up, was met with very high public expectations, just as your nomination has also been met with. But the public have very high confidence and high expectation in your delivery. However, some have held the view that your predecessor was unable to fully discharge his mandate and even to full term. So what assurance can you give this committee that when given the nod, you will see through the discharge of your mandate fully, and that somewhere along the line you won't throw in the towel should you encounter some challenges?
Honorable Chair, if I see through this office, I will be leaving at the end of a 7-year tenure on my 50th birthday. The gift I want to give myself when I turn half a century is that the OSP solidly established
The journey to find out one queen continues. Last week, our contestants put up splendid performances.
Freedom! Freedom at last! So in the wake of a new dawn, people of Ahafo are not just courageous, so we are hard working.
This week, the battle gets keener as our ladies have been tasked to identify a cultural practice that they would like to modern.